Chair recognizes the gentleman from Virginia, Mr. Griffith, for 30 minutes.
Thank you very much, Mr. Chairman. I would have to say that this particular bill is not about the debate regarding global warming and what the United States should do. This is about making sure we follow the law. As you will recall, when Laurence Tribe was in here, an environmental leader, a lawyer, though, who believes in the Constitution, said, while I agree with the goal of what this bill is trying to do, it doesn't follow the law, and you can't burn the Constitution in order to meet the goals that you want to meet. And that's what we're talking about. And the legal basis for this law is extremely weak. And I believe the EPA knows that. In fact, when you look at the evidence in this matter, you have a situation where the EPA in 1995 made an interpretation over the same dispute they now claim they have authority in which to regulate under, and came down on the other side. Now, that wasn't during a conservative Republican administration. That was during the Clinton administration. Further, in 2008, dealing with the Clean Air Mercury Rule, CAMERS, a court ruled in New Jersey that, according in view of the plain text and structure of Section 112, referring to the Clean Air Act, we grant the petitions and vacate the delisting rule. This requires vacation of CAMERS regulations for both new and existing EGUs, electric generation units. EPA promulgated the CAMER regulations for existing EGUs under Section 111D, but under EPA's own interpretation of the section, it cannot be used to regulate sources listed under Section 112. EPA thus concedes that if EGUs remain listed under Section 112 as we hold, then the CAMER regulations for existing sources must fall. EPA appealed that case, but not on that ground. They conceded the point on which they now wish to regulate. And then again in 2011, the Supreme Court of the United States, in a note, footnote 7, in the American Electric Power versus Connecticut case said, there is an exception. EPA may not employ 111D, if existing stationary sources of the pollutant in question are regulated under the National Ambient Air Quality Standard Program, and includes some other sections, but also includes Section 112. So the bottom line is that the EPA knows they're on weak ground. So this bill is important because the law is weak and the threat is great. The State Corporation Commission of Virginia estimated that just one of our many power companies, Dominion Virginia Power, that it would cost them substantial money, between $5.5 and $6 billion. And they state, and I quote them, contrary to the claim that rates will go up but bills will go down, experience and costs in Virginia make it extremely unlikely that either electric rates or bills in Virginia will go down as a result of this proposed regulation. Mr. Chairman, the law for the EPA is weak. The threat to the states is great. This bill is a bill whose time is right and whose merit is great. I urge that we pass this bill forthwith. I yield back.
Thank you, Mr. Griffith. At this time, the chair recognizes